Welcome to Employee Benefit Plans and Business Sense.
Hey everyone, welcome into an all-new episode of Employee Benefit Plans and Business Sense with Lank and Kathleen Bass over at KLB Benefits Law Group. I am your host, Mike Leon. And Kathleen, they've been helping employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. They've got decades of combined experience in employee benefits law, and they help businesses understand how federal rules apply to their real world operations. And in today's episode, we're going to be talking about related employer groups and how they affect benefit plan compliance. Ladies, it's good to see you as always. I'll start with you here. What is a related employer group for the audience listening when it comes to employee benefit plans?
Thank you, Mike. It's a pleasure to be here. A related employer group is a set of employers that are related to one another by either ownership or service relationships between service entities. It's usually in the connection is created by at least a little bit of overlapping ownership, and in the case of in some cases it requires a lot of overlapping ownership, and other groups can be created by a little bit of overlapping ownership and service relationships. So the key is joint ownership by a single entity or person, and in the case of service entities, it's service relationships. That's what can create employee benefit related employer groups, which is a defined term in the code.
So then how does that impact employee benefits and the way these plans are structured and tested for compliance then, Dahl?
Well, the effect of being a related employer group is that the more than one company, the two companies, three companies, four companies that are related, are treated as a single employer for purposes of two main things in benefits. One is the ERISA plans, the retirement plans, and other plans offered by the employer, and also under the Affordable Care Act, related employers are treated as one employer, one entity when counting the threshold requirement for coverage under the ACA. So those being treated as a single employer means that these small companies, smaller entities, when combined, have a different profile of employee population, a different mix of highly compensated and non-highly compensated employees than each individual entity might have on its own. So the
So then how does an employer, Dahl, know whether they are in a related employer group?
there is no intuitive reason to know. You must know the law, and so if you're advised by counsel or somebody else who's knowledgeable, like a CPA, for example, is aware of these rules, then that's how you know. But the real bridge between the employers that creates the group is cross ownership. So if you're an individual or trust, or if you're the individual who's a beneficiary of a living trust, for example, or if you're even an estate, if you're if you as an individual, a trust or estate have ownership and equity interest in more than one entity that employs people, then you should be on alert. That's the first clue that there could be employer relations that relationships among the employers that would create this related employer group for benefits purposes. So if you own a big percentage of one business and then you acquire a big percentage of another business, if those businesses have employees other than yourself, you should be on alert that there could be an issue. There could be related employers. The big there's another kind of there's strict ownership that can create, strictly just looking at ownership can create a group. Also, ownership plus service relationships in the case of service entities, and also in the case of service entities, no overlapping ownership is required for a certain specific type of related employer group where the service relationship is very intense. Without getting into the details, so there's ownership only can create a group. Ownership plus service relationships can create a group for service entities, and for service entities, even without ownership, the service relationship can create a group.
Yeah, and I would just add on that sometimes these things appear very simple, fairly like to an employer, they think this is it, my business has nothing to do with my wife's business. So how could they be related? Well, I think of this whole related employer analysis as like a spider web. There's all these connections, and a lot of time when we start looking into, what the related employer group might be, we're looking at ownership, but then there's, you have to, certain family relationships create some attributed ownership. As Dahl alluded to, if there's a trust involved, then, you have to look at the beneficial ownership of the trust and things that are not, and then the service side of the analysis. It's like it's all these facts and circumstances that, a lot of times employers don't think about this. Like there's, oh, I only own a little bit of this other company, and like
Right.
1%, and that can actually, if there's some shared service providing shared services to people or to each other. So I guess the main point is that it can be what seems
Yeah.
to be a clear situation can end up being quite a big related employer group, once you start sort of looking under the hood, just to
Right.
change my
Yeah.
metaphor there.
Right. Well, and it piggybacks into the follow up perfectly, which is what does, and Dow, you can take this, what triggers a change in this related employer group status?
Well, the ownership can change over time with one transaction. So the ownership profile of an entity may change, will change in an acquisition of another entity. It will change in a spin-off from within the entity. The different configurations of ownership can change just with a simple stock transaction. Stock issuance by a C corporation to a new investor may trigger a new owner ownership profile, if you will, that could trigger related employer status. Now, there are thresholds that have to be met in connection with ownership amounts, but it's not worth in an overview of the topic. It's too difficult to get into all of the different um, uh, sort of mathematical formulas that would apply to ownership that would create these related employer groups without giving the impression that in the absence of this ownership there is no group. Sometimes there is a group, for example, with the affiliated service groups, which are the service related and the entities related by service activities. The ownership percentages can be quite low, and the service relationships can trigger. It's the service relationships that can trigger the affiliated service group status, even in the case of low ownership. So it's hard to, the listener should be aware that the facts and circumstances, if they're a service entity within any sort of ongoing and more intense relationship with another service entity, and if there's any cross ownership between those entities, they should be on alert that there could be a related employer group there. But what triggers it is typically, I mean, what commonly triggers it is an acquisition or a spinoff.
Yeah, and I was just gonna say, I've actually seen where there's been no acquisition or spinoff, but they just sort of company just decides to reorganize a little bit,
Mhm.
and for whatever reason, and that somehow changes the analysis of what is or is not a related employer group. So any sort of change in any of these sort of factors is could create or make a related group disappear, depending on the situation. So um, it's just that's why they're kind of sometimes hard to identify that there's been some sort of a
Yeah.
change, especially since some companies haven't even gone through a related employer group analysis to start with. So, they don't even know who's in their related employer group, and then they have a change, which, so
Right.
anyways, that's can be it can be very complicated and very fact driven.
Right. Well, then it makes me think because, and Dow, let me ask you, if an employer discovers now they're part of a related group, what should they do next in terms of reviewing their plans?
Well, they should engage counsel to review their plans and especially look to the date on which they became a related employer group and the circumstances that created the related employer group, because there's a grace period for acquisitions for changes in related employer group status that come as a result of an acquisition or a spinoff. There's a 1 year grace period. It's actually a little bit longer than a year. It's actually for the year following the year of the transaction, till the end of the year following the year of the transaction, there's this grace period. So if your transaction occurs in February of 2026 and both the plans are in compliance, your plans don't have to be considered under these related employer rules for until the beginning of 2028, till the end of the year after 2027 of the transaction. So that beautiful grace period is in place to give employers a chance to deal with the fact that they will be treated as related employers when it happens as a result of an acquisition or a spinoff. And so the very first thing that anybody should do, if a professional alerts them to the fact that they could be in a related employer group, they need to engage ERISA counsel to deal with all of the ability to use this grace period, because there are a few conditions there, and the timing, and prepare for the main task is to understand the responsibilities and prepare for them. Because if you have that grace period, let's say it's 18 months, in fact, you need that time to prepare for how you're going to change the benefit design, or consider changing it for the effective date, so that you can afford to have these coverage requirements, the benefits coverage requirements.
Yeah. Dahl, let me ask you, what about this employer status? Can it affect retirement plan participation or even coverage testing?
What's the effect of it? Well,
Yep.
the effect of it is it creates this new population that has to be taken into account for all of the arithmetic, all the mathematical formulas that go in connection with coverage and non-discrimination under ERISA. This is for benefits plans. For ACA, the effect of being a larger group, is that you may, as that group now, be required to provide minimum coverage under the Affordable Care Act if you have 50 or more. If you're an applicable large employer, right, Kathleen? That's the term.
Right. An ALE, applicable large employer, is
Yes.
generally if the employer has 50 or more full-time equivalent employees during, the year, then, that's sort of the general idea of it. And again, that could be a whole podcast in and of itself, but yeah, and it gets complicated when you have a company that's already like a ALE buys a company that isn't an ALE, and the point at which that other company becomes an ALE because it's being aggregated, or two small companies, merge, and then they become a large applicable large employer. So it can definitely have an impact, and how you handle it gets very complicated.
Yeah.
Yeah.
So, ladies, let me ask you then one takeaway for each of you. I'll start with you, that you'd share with these employers about staying compliant as maybe their ownership changes, or like Kathleen mentioned, the structure evolves at the company. What's one takeaway you shared with them?
My takeaway would be to be conscious of cross ownership in particular, and be conscious of anything that seems like any change to your benefit plan design that you might be doing for the sake of excluding a particular population. For example, if somebody advises you to create to after a merger, if a third party administrator or plan consultant starts looking at your population and what you're going to do to limit benefits after a merger, you might have other issues that you might not be allowed to do that. It might be tricky doing that. These are, I guess, be sensitive to the plan design when there's cross ownership, in particular, when there's any sort of cross ownership. That's the biggest heads up.
Yeah, and I would just add that, again, these these are very complicated analysis most of the time. It's like pulling the thread on the sweater, and it just keeps coming, and we find all this information out. So I would say, definitely, if there's a transaction being anticipated or any sort of change, contact ERISA counsel, because it's rarely as simple as it seems.
Really, as simple as it seems. I love that. That's the way we land the episode. Ladies, thank you for the time and insights as always. We truly appreciate it.
Great. Thank you, Mike.
Thank you, Mike.
And thank you to everybody out there for listening to this installment of Employee Benefit Plans and Business Sense. Look, if you're unsure how related employer rules might affect your company's benefit plans, do me a favor right now. Visit klblawgroup.com to connect with Don and Kathleen. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.